My name is Ryan Campbell, and I am the IP Geek of theipgeek.com. We're over here at Geek Corner, coming to you live from the Bushwick Copyright Cave. And today we're going to be discussing the Andy Warhol Foundation for the Visual Arts v. Goldsmith, a case that has deep implications on intellectual property and fair use. This is very much a First Amendment versus proprietary rights case. It can get a little bit complicated, and today I'm specifically going to be covering oral arguments. One of the things that I find pretty striking in the oral arguments was just how quickly the AWF side returned to what I consider a disingenuous argument in claiming, and they get a little bit emo on us here, a complete banishment of meaning or message. That's at 2:15 as per the C-SPAN viewage. Now, the problem is that the Second Circuit in no way banished the meaning or message consideration. Now, this is a direct quote from the Second Circuit's decision. Whether a work is transformative cannot turn merely on the stated or perceived intent of the artist or the meaning or impression that a critic, or for that matter a judge, draws from the work. Where otherwise, the law may very well recognize any alteration as transformative. As we have discussed, the courts must examine how the works may be reasonably perceived. The judge must examine whether the secondary work's use of source materials in its service a fundamentally different and new artistic purpose and character such that the secondary work stands apart from the raw material used to create it. Although we do not hold that the primary work must be barely recognizable, the secondary work's transformative purpose and character must, at a bare minimum, comprise something more than the imposition of another artist's style on the preliminary work, such that the secondary work remains both recognizably deriving from and retaining the essential elements of its source material. Now, the most important word in there is merely. Whether a work is transformative cannot turn merely on the stated or perceived intent of the artist or meaning or impression that somebody decodes from it. Now, in the closing argument, I felt like they continued to quadruple down on what feels like a bad faith argument in trying to set up a Hail Mary pass for themselves, saying that they conceded that you can consider meaning or message, that the Goldsmith side did, and that this requires a reversal of the Second Circuit decision, which, no. Both sides go to the Campbell v. Acuff Rhodes case, but they both have pretty different takes on it as far as what it should allow, what it shouldn't. Now, I personally find it convincing that parody requires an additional leverage of how much leeway of how much you can take. Fourth factor pivot. This was actually a pretty gross one. The AWF side started arguing that the fourth factor would be what stands between a book and a movie being based off of the book, saying that the economic effect to the intellectual property of the book, even if the movie is different and has a different meaning or message and would qualify as fair use under their analysis, this would not be prevented from happening via a fourth factor analysis, that the market effect would decimate the book, I suppose. But the problem is, I mean, ask George Martin. He's probably making way more money off of his books after Game of Thrones became very famous than he was previously. The fourth factor market effect is completely unavailing in these cases. In fact, there would be many products that would be infringing but would still have synergy with the infringing property such that the original property would see a resurgence. For example, if Stranger Things did not compensate and didn't pay for licensing or the rights to play Running Up That Hill, Kate Bush would still be making much more money right now after the show had her song as the crux of one of their climactic scenes than she would have been if this was not the case. That doesn't mean that if they didn't pay to license the music, they wouldn't still be infringing upon it. And another point that came up a couple of times is statutory derivatives. You have a statutory right, as per the Copyright Act of 1976, of making derivatives. What kind of derivatives can you make if somebody can infringe on your original art, but just have things be a little bit different, or even just give it a good explanation, and so, hey, this work is completely different because I made it in Palestine, whereas the original was made in Israel. It could be considered having a different message for any number of reasons. The different meaning or message is so subjective that it would completely wash away certainty for artists in any regard. If we want to protect artists and we want to protect art, we need to draw some lines, and the AWF side draws almost none. Thank you for watching the IP Geek at Geek Corner. This is my cat. I love him. You can see that he's thrilled.